Federal High Court sitting in Abuja has adjourned the trial of Nnamdi Kanu, the leader of the Indigenous People of Biafra, till October 21, 2021. The trial, which began at 11:06 a.m. on Monday, was adjourned on the grounds of the Department of State Services' failure to produce the IPOB leader in court. Justice Binta Nyako, who led the proceeding, faulted the actions of the DSS and also asked the prosecution to be diligent with dates whenever she gives one, noting the importance of Kanu's presence for his trial. The prosecution, Mohammed Abubakar, in his response, told the judge that the defendant was not in court owing to logistics reasons. Kanu's lawyer, Ifeanyi Ejiofor, on his part, said the DSS has denied them access to the defendant for the past 8 days. He urged Justice Nyako to grant the request of his client seeking to be transferred from the DSS custody to the Kuje Correctional Center in Abuja, and also grant Kanu access to his medical doctor for the purpose of carrying out a comprehensive independent medical examination on him. After listening to both parties, Justice Nyako said she would give an order for access to the defendant. Justice Nyako, however, declined the proposal of the defense counsel that Kanu should be transferred to a correctional center, ordering that he should remain in the custody of the DSS. Nnamdi Kanu's lawyer, speaking with newsmen after the court sitting, said,
"He was granted bail by this court, and all the orders given by the court for his unconditional release were all flattered by the DSS. So, and subsequently, we filed application successfully challenging the 11-count charge we filed against him at the time. And the court, after listening to our application and hearing on the merit, struck out 8 counts out of 11-count charge, remaining 3. A portion to which an appeal was granted on 25th of April 2017. So, and it was scheduled to be in court on October 17th, 2017 for trial. So, somebody who's enjoying the court bail. And on 14th of September 2017, the military soldiers and Nigerian government took war to his house and invaded his premises, during which period they killed over 28 persons. So there's no doubt about it that we are there to assassinate him. So, and by sheer act of providence, we escaped from their life. So we have resolved the issue of not being bail at this stage. We have applications before this court, urging the court to also investigate the circumstance that led to his disappearance. Intervening event, what led to the invasion of his house, one invasion of his premises. The court need to hear it. This application happened before the court before now. He was tortured, he was beaten, and also left with severe pains and injuries, which is still suffering for today, where he's been detained. So, and after 8 days, they made a contact with the Nigerian government security team, who eventually moved in there and they smuggled in here under a process commonly classified under the war norm as extraordinary jurisdiction. So, and those infraction and international breach of humanitarian rights, and also and Geneva Convention Protocol, which Nigeria signed in 2001, are being challenged today effectively by law in Macron and our foreign partners overseas. We have filed application in African Union Court. UK is also on it, and US is also on it. So that infraction has to be addressed because it's fundamental. Because you can't place something on nothing and expect it to stand. So we are compelling on the part of this authority today and the obligates on their own part to ensure that a citizen who was subjected to this kind of torture and inhuman treatment is restored to the position he was at the point he was arrested. Because that obligation was actualized, we are sure, and we are taking steps to ensure that is done. Because what we are talking here, if they've killed him in Kenya, we're not talking about trial today. If they've killed him in his house when they were in house, when they invaded his premises on 14th of September 2017, we're not talking about trial today. So, and if you allow it to stand, the man I wish was abducted, kidnapped in Kenya, and exported to Nigeria, it will be a precedent before the international arena. And we can't allow it to stand. And the international court is on it. We have taken steps to file and processes before the international court, which is presented by law in Macron and our partners over there. So these are abnormalities that need to be resolved. Because Nigerian international image, if any is still left over, has been damaged abroad, overseas. And it has to be condemned by all reasonable persons, responsible foreign government and institutions. It has to be condemned because look at what happened to Nnamdi Kanu's case. Nnamdi Kanu was arrested in Benin as well as the country. But today they refuse to listen. He has to subject him through what they call the extradition process before they can find if there's any merit in what allegations against him in the first place. That's what it's supposed to be. If I arrested him through the normal process, you are subjected to prosecution proceedings to find if there's any merit in the allegation against you. We are aware that we are here on political trial. Nnamdi Kanu is here on a political trial. And the fullness of time will be out. We are sure, and I can confirm to you that he will be released. He regain his freedom sooner than expected. Now, we are taking a discussion. We are discussing with the court and also with the council on the other side. And the court director should notify the city for a fear to be obtained so they can hear this matter during vacation.
Also, one of Nnamdi Kanu's counsels, Aloy Ejimako, speaking with newsmen, said the federal government broke its law.
My colleague mentioned the doctrine of extraordinary rendition. Yes, it is real. It's not a fix or something the lawyers just made up. Nigeria ratified a treaty in 1983 and later on domesticated that treaty and adopted it part of our own domestic laws. And a very important article in that treaty prohibited extraordinary rendition by definition, by expression, express words, not by implication. So Nigeria broke its own laws. You know, people tend to think that, well, you are trying to make Nigeria's sovereignty subject to international law. No, international law implications are there, but this is also part of our own law. So what Nigeria has done has triggered a multi-jurisdictional response, including, of course, that of international law, Britain, and Kenya. So this is what we are dealing with right here. And to confirm to you that what happened to Nnamdi Kanu is wrong is what is happening in Benin right now. So if Nigeria believes that it's easy to go into another country and grab a suspect and possibly, remove that suspect and land the suspect in Nigeria, they could have succeeded in the case of IPOB. So it's playing out in the public. So there is going to be a lot of new dimensions that you are going to see as this matter begins to unfold.
The case was adjourned to October 21st, 2021.